Hi, I'm Greg Doe with Dell Disability Lawyers, joined by attorney Stephen Jessup. And today we're going to talk about one of Stephen's recently resolved cases against the Hartford. And we love to talk about these cases because it shows our experience in handling these cases, and it gives some good tips to claimants who have Hartford cases as to what they can expect when they get themselves in a situation where their claim has been denied. So, Stephen, give us the background of this claim, and then let's talk about how you were able to help our client to get their benefits paid.
All right, so my client is a former operations manager at Amazon, so he was in charge of a whole fulfillment distribution center overseeing all the managers, all the personnel and staff. So he was an executive level within Amazon. He had suffered from lumbar radiculopathy, some arthritis in his right hand, and at the inception of the claim, some cervical neck issues, but the impetus was really with his lower back. He filed the claim for disability in October of 2018. Hartford was handling the short term, approved that, and then when it transitioned in April of 2019, approved him under disability for being unable to perform, the material and substantial duties of his own occupation. Shortly thereafter is when he contacted our office. He'd only been on claim for, not even 5 months when he got notice that Hartford wanted to send him to an IME. So he was leery and worried. He had done a lot of actual research, found us online, actually I think it was from YouTube, and wanted just some advice and suggestions on how to do it. And that's when we started representing him in preparation of what Hartford might be up to at that point.
Okay, so what happened when he went to his IME exam?
So the IME was set for, I believe it was November 16th of 2019. I don't trust IME doctors. I don't think most people trust IME doctors. So to try to get a better idea of what may be the restrictions and limitations, we actually sent him for a functional capacity evaluation the day before the IME. So
I just want to back up a second. First of all, what's an IME doctor? Because a lot of people don't know what we're talking about.
Well, an IME doctor is an independent medical doctor. So this was a doctor Hartford says, we want you to go see to do an evaluation to see what your restrictions and limitations are. A lot of times insurance companies will use these IME doctors as the impetus for a denial of benefits. And under ERISA, which governs this as an employer-provided policy, the insurance companies are always working towards this idea, if we get in court, can we show that we didn't act arbitrary and capricious, or we had a reasonable basis to deny the claim. Most of the times they won't send you to anyone, they'll just do file reviews. So when they're sending you for an independent medical evaluation, they're already thinking, how can we prepare to strengthen our file for any potential litigation down the road to give us the greatest chance of success.
All right, so when you were contacted, he was still getting paid, but you knowing that Hartford was requesting an IME, that's usually their code word for we're looking to deny you.
Exactly.
So he hired you then at that point?
He hired us, yeah, it was about a month out from the IME.
Okay, so you already were thinking they're likely going to deny you because most IME doctors find that you're not able to, that you are able to work and want to try to get you back to work, and so you were putting a plan in place anticipating a denial.
Correct.
Okay, so what did you do?
So like I said, the day before the exam, we sent him for a functional capacity evaluation, which is formalized testing to determine what your abilities for work are according to the Department of Labor. The insurance company uses these standards: sedentary, light, medium, heavy, very heavy. Interestingly enough, even though he was executive level, his job is classified as medium duty because he is still required to also work the floor, lifting up to 50 pounds and stuff like that. So Hartford was looking as a medium duty occupation. So we sent him for the functional capacity evaluation. Now, we don't have the results, prior to the IME.
Right.
So he does go to the IME. I make contact with him. We discussed what happened in the IME. He believed that the doctor gave him a fair shake, more or less. We got the IME report. The IME report said that he was incapable of full-time sedentary work based on the lumbar problems. We even sent it over to the IME doctor for review and comment. Now, the IME doctor did say that he was going to stick to what his restrictions that he was placing. Now, at this time, we don't know because Hartford doesn't have a duty to turn it over to us at this point, but that he did find that the FCE was an accurate reflection of a lot of the complaints our client had. So we figured this IME is probably going to be supportive then. The only way we knew it was supportive is Hartford didn't deny the benefit. As you know, unless there's a denial, they don't have a duty to turn over that IME report, and they wouldn't turn it over. So we were able to avoid any disaster at that point. But this policy, like most, also is going to have at the 24-month mark, which came due in April of 2021, a transition from own occupation to any occupation. You know, can you do your own job to can you do any occupation based upon training, education, experience? The caveat, though, with his policy was he had to be able to make 80% of his pre-disability earnings in this alternate occupation. He was a high wage earner for Amazon, which is part of the reason why Hartford was looking for reasons to deny him. From our analysis of vocational stuff that we had done in advance and in preparation of what may happen at 24 months, there was really no jobs that would fit the criteria except his former occupation. So we felt pretty confident going into that 24-month review. Well, December of 2020, Hartford again decides we want to send him for an independent medical evaluation.
Wait, okay, so you basically, you saved him the first time, I mean, gave him great advice, got prepared and got over the first IME. Now the definition changes and they want to do another one?
They want to do another one a couple months prior to it. So we get him smoothed out into 2020. By the end of 2020, they want to send him to another doctor. The doctor they wanted to send him to is a doctor whose name I've seen before in Hartford files. So we were especially leery with this one. Again, we decided we were going to also submit, have him go to an updated functional capacity evaluation with the same examiner, and it was scheduled a couple of days prior to the IME exam. At the IME exam, and this is interesting because our client lives in Texas, which it's a one-party state with regards to recording. He recorded the IME from a phone in his pocket. Okay. When we got the IME report, Hartford was giving us the ability to, respond and take a look at it. This IME report was indicating all kinds of ability and these opinions of the doctor didn't make sense. So knowing that just having the recording wouldn't necessarily be enough, we went and we actually had it transcribed by a court reporter. That took it and made it like it was a depot transcript that was going to be a part of the appeal because we had a feeling that they were going to look to deny on this. We even provided this doctor with a copy of the functional capacity evaluation, and the doctor was of the opinion that it didn't support, it wasn't based on clinical research and evidence, which basically were buzzwords. This is what this testing is. It's actual, it's clinically based, standardized testing. So we were expecting that Hartford was going to look, based on this IME report, was going to try to look to deny into the any occupation stage, which would have been April of 2021. They actually denied the case a month and a half before, during the own occupation period, saying he could return to his former occupation. So you and I know that this is a common game with Hartford and a lot of the insurance companies, that they will deny prior to that change in definition because we could submit an appeal and they could say, oh yes, you're right, he couldn't do his own job, but we think he could do other occupations and get another chance of denial. So preparing this appeal was going to take a lot of work and a lot of additional support and building up because now they have an IME that is supportive of them. They're going to lean on that to show that they provided a reasonable basis. Thankfully, at this time, because there is a denial, they had to turn over the entire claim file. And we had the initial report from the doctor in 2019, the full report of this IME doctor, which we had before, and even some vocational information that they had done in lead up, because they were evaluating, even though they denied him an own occupation, they were evaluating the any occupation. They did a full vocational analysis as well.
And so what did you basically do in anticipation to handle the denial?
Well, this is where the transcript of the IME really came into handy. We used that to really discredit the doctor quite a bit. What he was reporting was told to him, or things that he observed or saw just didn't gel with what the transcript from the IME had to say. It really documented a bunch of restrictions and limitations, where the doctor noted issues in range of motion, these various different factors. So we used that to really attack. The client underwent updated MRIs, both of the lumbar and cervical spine. He had EMG studies done, a static EMG and then a traditional EMG.
All of this after the denial?
All of it after. We went full board on it. He had all these updates done with his doctor. And then, just working with his doctors to try to get additional information to combat what the IME doctor had to say.
The EMG and the MRIs are considered objective testing. Why is that so important in your appeal strategy?
They were already all there. Nothing really changed from the prior reports from 2020. We figured we'd get updates to see if there was worsening. Some worsening in the cervical, lumbar was basically the same, but all the time an insurance company is going to argue that your pain is subjective, and it is. Only you know what pain you're in, how you feel. So they try to determine what the level of your pain is based on what the objective medical evidence shows. And that is your MRIs, your EMGs, your CT scans, things like that, where you can look at an MRI and go, oh, there's a severe problem in his lower back. It would make sense he's experiencing these pains. Oh, he says he has numbness and pain radiating down his leg. Well, the EMG studies, they support that. So we did a full host of updated exams there. To just show that it's nonsense. And then we actually used the first IME report all the way back from 2019, now that we had it. That doctor gave the client, at best, light duty ability and made it clear that he was not expected to improve, would likely worsen slightly over time, is likely not to return to gainful employment in what he used to do. So we have this IME doctor who is supporting disability. And then like a year later, we have an IME doctor that says the client can lift 100 pounds and shouldn't have any restrictions whatsoever. So we used a lot of the information that Hartford had early in the claim against them. And then knowing that there's going to be this issue from the own to any occupation where they're going to do that, we really attacked the vocational analysis, which to me was laughable beyond belief. The vocational specialist had found 19 occupations that met his training and education, but only 2 met the criteria of 80%. And I must have read this 5 times, and math is not my strong suit, but in her report she says 80% of pre-disability, of index pre-disability earnings would have to be a job that pays $14,000 a month. The 2 jobs I identified pay between $8,000 and $10,000 and would satisfy the 80% requirement. I'm not good at math, but $8,000 to $10,000 isn't the same as $14,000, so we really attacked there. And submitted. I mean, the appeal with all the medical information was almost 700 pages that we submitted over to them. A lot of times Hartford, once you submit it, they have 45 days to render a decision. With the possibility of a 45-day extension. In this one, they made a decision prior to the end of the 45 days that not only included disability from own occupation, but also into any occupation. So as of right now, he's approved in any occupation, and he actually just was awarded his Social Security. And his intention, which I've done quite a bit with Hartford as of late after winning appeals, once the overpayment is satisfied, we're going to look to even negotiate a lump sum settlement so he doesn't have to, live under the pressure and scrutiny of Hartford.
The takeaway I get from the work you did in this one was not so much, of course you always write a great appeal, but it was more the strategic planning that made the great appeal. And I think that's the advantage of having so much experience in doing this, that had you not guided him as to all of the things that have to be done, and we always say it's like writing a script for a play or for a movie, that you have to plan ahead as to how you want everything to come out. And had you not done that for him, I don't know that there would have been any chance for him to win.
It would have been tough to do it after the fact. When we first spoke, great guy, early 50s, high wage earner, red flags. So you knew that there was going to be, so it was going to have to be set up. And here's a guy who runs and handles logistics, so he understands preparing and looking at the long road on it. So this was one of those situations you could have the greatest information possible, and Hartford was still finding anything that they could just sink their teeth in to deny the case, to see if someone would fight them on it, or if they could get it into court and really make this argument, oh, our IME doctor, we can reasonably rely on those opinions. So it was a tough case, very happy with the outcome, and we're hopeful that now Social Security is approved, that's the last thing that needs to be handled, and maybe we can get him a buyout and he can just be done with them.
Well, it's a fantastic outcome. Congratulations to the client. I'm sure he's happy, and now he can focus on his medical conditions and getting himself better and not having to so much worry about Hartford, although Hartford's always going to continue to look at the claim, and I know you'll continue to handle the claim and guide the client as to what he needs to do on a monthly basis to keep his benefits from being denied in the future. at his young age of being in early 50s, like you said, it's not going to be surprising if a year, 2 years, or 3 years from now, Hartford wants another IME. And we'll go down the same road again and show them that this is a deteriorative condition. He's not getting better unless there's some miracle treatment or drug or something that comes along, which he would love. All of our clients would love to go back to work rather than make 60 or 50% of what they used to make. But until that happens, I know you'll continue to fight for him. So congrats again. So if you have a Hartford claim and need help with a denial, or you're applying or anything, feel free to call Stephen or myself, and we're happy to assist you. We're available all over the country and always provide a free consultation. Thank you. Hi, I'm Gregory Dell, the managing attorney of Dell Disability Lawyers, and I hope you find the video you just watched helpful. We put these videos out all of the time, and we'd love if you would subscribe to our YouTube channel. Beyond our videos on our YouTube channel, we also have lots of information available on our website at diattorney.com, and we encourage you to come to our website. The goal is that we want you to be educated about the disability insurance process, and when you get to our website, you'll see that we have information all about your specific disability insurance company, your occupation, and your medical condition. And we've designed our website such that you can easily search our website to find things that you may specifically be looking for. Now, at our website, we have thousands and thousands of pages of information, hundreds of videos that you can search, plus we're building a section of reviews of all the disability insurance companies, and we have the Ask Our Lawyer section where you can go ahead and ask us any questions that you may have. Now, we realize that you may not need us right now, but you may need us in the future to help you with your disability claim, and we think one of the best ways to keep in touch is by clicking the button below and subscribing to our channel. And most importantly, again, no matter where you live in the country, we're always available. Just go ahead and give us a call. We're happy to discuss your claim and let you know immediately if we can help you.